In an ex parte pleading, so delivered right to the court and delivered shortly after today's deadline, the government again evaded its obligations. In addition, to avoid further delay, the court required Trump to show cause. That's like you're getting called to the principal's office, man. You're busted. On the facts that they have already disclosed as to why the failure to return these class members aboard the two earliest planes did not violate our TRO. Wow. So why didn't you bring them back? Judge Boasberg, the deportation judge, is not happy. He gave several deadlines to President Trump, and Trump is fighting back. He's taking this up to the Court of Appeals to have them opine on the issue in front of this judge specifically, but he's also doing an end run around this judge and going to the Court of Appeals requesting a petition for a writ of mandamus. Here is what the judge wrote today. Not happy. Said, on March 18th, the court ordered Trump to provide by noon the following day specific information about the flights carrying the Tren de Aragua terrorists out of the country. The judge says, I issued a TRO and then you flew them out of here. But Trump instead filed a pleading shortly before the deadline, which was yesterday, to seek to stay the order in large part on the ground that they were considering whether Trump was going to invoke the state secrets privilege. Now, although the judge writes, Boasberg, although skeptical of the applicability of that privilege to this case, the court granted them another 24 hours to either release the information that was ordered, which were all the specifics about the flights, who was on it, when to go, who gave the orders, and more, or to invoke the privilege. We covered this at length yesterday. But then, in an ex parte pleading, so delivered right to the court and delivered shortly after today's deadline, the government again evaded its obligations. Now, it's ex parte, so we didn't see this submission, but the judge tells us. It submitted a 6-paragraph declaration from the acting field office director from ICE, and the contents of which the government has informed the court may be disclosed. But after 4 paragraphs of identifying information, so this guy's like, oh, hi, he writes this memo. The judge wants a memo. All right. How many pages does it have to be? 5. All right. Can I do 4 pages for my introductory paragraph? My grade school teacher wouldn't be happy with me, but let's do it. So it does. Okay. Hi, my name is so-and-so. I'm the director, removal, Harlington. My background and training is the following. I was born in 1965, and after a long term of high school, I was a little bit confused about what I wanted to do with my life, but I found a mentor, and it goes on for 5 pages. He trained me in the foothills of the Himalayas, and then finally came back, and I work at ICE. Like, okay. Judge writes, on March 15th, he gave us the same information after all of that. It's the same stuff we already knew. He said on March 15th, 2 flights carrying aliens being removed under the Alien Enemies Act departed U.S. airspace before the court's minute order of 7:25 and before the court's oral statements during the hearing. He's like, oh, you want a statement? Here you go. Shout out to Robert L. Cerna. He then stated, I understand, and the judge is not happy about that. I understand that cabinet secretaries are currently actively considering whether to invoke the state secrets privilege over the other facts requested by the court's order. Doing so is a serious matter that requires careful consideration of national security and foreign relations, and it cannot properly be undertaken in just 24 hours. So the judge says, oh man, this is woefully insufficient. He's mad. I ordered answers. He says, to begin, the government cannot proffer a regional ICE official, Robert, to testify to cabinet level discussions of the state's secret privilege. Indeed, his declaration on that point is based solely on his unsubstantiated understanding. He's like, you gave me somebody who doesn't know anything about this. Now, although its skepticism concerning the suitability of this privilege was expressed yesterday and it remains, the court at a minimum requires an official with direct involvement to swear that deliberations of the privilege's invocation are ongoing at the level that Robert Cerna attests to. It further expects that such deliberations to be concluded by March 25th, which only exceedingly good cause may excuse. So we do have a deadline by tomorrow, telling us, in addition, to avoid further delay, the court required Trump to show cause. That's like you're getting called to the principal's office, man. You're busted. You have to show cause on the facts that they have already disclosed as to why the failure to return these class members aboard the 2 earliest planes did not violate our TRO. Wow. So why didn't you bring them back? Why didn't you bring them on the 2 earliest planes? Is he saying that they should have been turned around in the air, or after they landed, they should have been brought back? Further supplementation may be required, but the court accordingly orders by tomorrow, March 21 at 10 a.m., Trump shall submit a sworn declaration, or his cabinet, by a person with direct involvement in the cabinet level discussions regarding the invocation of state secrets. So on my desk by tomorrow. And by March 25, the Trump administration deportation shall submit a declaration indicating whether or not the government is invoking the privilege. So there are discussions, then an answer. And you shall file a brief showing cause why they did not violate my order. Okay, I think you did. You need to come show me why you didn't by failing to return the class members on the 2 earliest planes that departed on March 15th. So why did you not bring them back? And the gangbang ACLU lover lawyers who love representing terrorist gangbangers are ordered to file a response by March 31st, 2025 as to why they love gangbangers so much. And the judge, James Boasberg, of course, signed off on that one. Now, this judge is a hack. We've seen this before. He was also somebody who played a key role in the Trump-Russia FISA saga. Same judge who's blocking the Trump efforts to deport these folks is the same one that was nominated by Barack Obama. His role was the head of the FISA court. He made a number of decisive decisions, including a slap on the wrist for the Crossfire Hurricane team, the appointment of officials who defended the FBI during the Russiagate scam, and the renewal of the FISA powers. And so this judge is going after him. And we know what it's all about. Not justice, it's about politics. But Trump is not lying down. They have submitted from the Trump administration a petition for a writ of mandamus, going around this judge saying he is violating his authority and that the United States Court of Appeals for the District of Columbia should step in and do something. So from Trump's DOJ going to the Court of Appeals explaining that Judge Boasberg is acting out of line. All right, guys, Court of Appeals. Pursuant to the All Writs Act, the government respectfully asks this court to issue a writ of mandamus. So we're asking you to order Judge Boasberg to quash the district court's order, which is the discovery order, which says, tell me who was on the plane, who made the decisions, and more, which permits this court to take broad, intrusive, and unnecessary discovery into the activities of the president and senior advisor Elon Musk. The government additionally asks for a stay before discovery would be due. Now, the district court is ordering discovery from Elon and Doge. It's unusual, it's highly invasive, and the Supreme Court has already made clear, and discovery directed at senior advisors to go get information against Elon is the rarest thing that should happen. It should only happen when strictly necessary. And the court also rejected views based on the idea that you're intruding into the executive branch. Now, the district court's order flouts these principles at every turn. Rather than allowing discovery as a last resort, they're allowing discovery now, before anything has even happened, before even resolving the government's motion to dismiss. And so, as the government explained, discovery is irrelevant to their claims. Here's the claim. It's a violation of the Appointments Clause, is the allegation, and they're having this theory that Doge and Mr. Musk are directing the agency actions, but that's not what happened at all. In fact, the Appointments Clause issue is about Appointments Clause office holders. It's not about people with de facto influence, not control, over certain offices. So they're bringing their claim under the wrong provision. The district court brushed aside our concerns, and the threat to the executive branch is substantial here. They vaguely word their request, but all it's doing is burdening the White House, and so for that reason, the Court of Appeals should exercise its mandamus authority to stop the prevention of Doge from doing its job. Now, the order states that Doge is led by an administrator who reports to the chief of staff. Executive order came out. The parties agree that Musk does not occupy an office. He's a presidential advisor and special government employee. Now, a collection of states, so this is the states case, brought this against Elon and Doge. Based on their theories, they've moved for a TRO. The district court denied the TRO on the ground that there was no irreparable harm. But then they filed a motion for discovery, and that was granted. So they want all this information from Doge. Anything they've created, compiled, or edited, the production of all documents about Doge, broad interrogatories, a request for anything that Elon said, and more. Now, this is a problem because you can't go and subpoena the president, a co-equal branch of government, to validate their work. But the district court granted that, granted expedited discovery, and the judge says that they want expeditious resolution here. So in finding discovery to be necessary, the court declined to even address Trump's position, the government's position. The court acknowledged the government had made standing and merits arguments and recognized the unusual timing of discovery, but it adopted their demands basically in full, saying that the court changed the production deadline and approved it. So the Court of Appeals then, writes the Trump DOJ, should exercise its mandamus authority and block the discovery order against Elon and Doge. It is a clear abuse of discretion. It violates precedent. The Supreme Court has already made clear that requesting discovery raises the prospect of a constitutional confrontation between the executive and the judicial branches. If the courts are authorizing the inquiries into the branch when the branch is doing its proper proper duties, that creates a constitutional conflict, not Trump. Give us another case from Cheney. The Supreme Court made a decision in that one, and in it, the court expressly rejected the view that the White House could adequately safeguard its privilege over specific documents. The court vacated the denial of mandamus and instructed the courts to be sensitive to requests by the government for interlocutory appeals. And so what the lower level court is doing here is making the same mistakes. And so the district court ignored the constitutional burdens. There should be judicial deference that's afforded to the office of the presidency. The district court stated that discovery is burdensome, but then approved it. Now, the treatment of the burdens on the White House is irreconcilable with the prior precedent, and other case decisions have rejected the same rationale used by the lower level court, explaining that the reliance on the fact that Musk is not the DOJ administrator is similarly hard to understand. Musk is a close advisor who conducts briefings in the Oval Office. The other factors that they relied on only highlight similarities that support our argument. And so the discovery order is unjustified. In fact, they're seeking stuff that is immaterial to their lawsuit. Several categories have nothing to even do with anything that we're doing. They want planning information on what DOJ is going to do. It doesn't have any relevance to their claims. They can't go find new claims here. The purpose of discovery is to show what has happened, not to conduct a fishing expedition, which is all they're trying to do. And their request for details and names is not only intrusive, but plainly irrelevant to the merits of their claim. They say Elon is improperly appointed, but the information they seek doesn't go anywhere to an appointments clause. Their own concessions confirm no discovery is needed. They don't need to figure out where Elon Musk is appointed because everyone agrees he's not appointed to anything. He has no formal government authority at all. That is the end of the analysis. They allege a bunch of other things, but there is nothing else. The decisions in other cases also support our take. Such results would suggest that influential White House advisors hold offices, and then people would just make up offices for people who are influential. That's not how that works. So asking for discovery here is not necessary to ascertain the disagreements. We already know what the disagreements are, and the district court didn't even consider other alternative avenues. They don't need to get information from us. Plenty of other places where they can figure out what DOJ is doing without intruding onto a co-equal branch of government. Now, the district court should have given this argument more consideration, but just said, you know, we're going to benefit from briefing, and I'd like discovery so I can help decide. But they don't even have jurisdiction. Their lawsuit depends on a theory that conflates influence versus authority, and so they're missing the whole picture. And the prospect that they will fail is also likely. But the district court didn't care, just said, well, I don't know if they're going to fail or not. Let's have discovery. It's grievously overbroad, by the way. Everything they're asking for, FAQs, scripts, lists, charts, summaries, memoranda, everything. They also want interrogatories. They want to sit down and interview every single person working with DOJ, harassing government employees for doing their job. They want anyone who has worked with Musk, worked with DOJ, access or plan to access, the purpose of those access. This is everything under the sky that they're requesting for. And the breadth of this creates onerous ambiguities for the executive branch. You're forcing us to do a bunch of other things that is a clear intrusion into our privileges and into our constitutional mandates. The court revised the request and made other adjustments to that, but that doesn't mitigate this at all. In short, the court's discovery order flouts well-established principles governing litigation with the office of the president. It doesn't give us any benefit, and this is a generic appointments clause allegation that should be dealt with by you guys. And so this court should order and should grant a petition and grant a stay of the discovery order pending a resolution of this petition as requested in the stay motion. But they're also appealing the Boasberg decision, which is this filing here. So Trump's team submitted a reply in the Boasberg case, which is the deportation case. So Elon is doing a petition to the same court of appeals in a separate case. This is within the same case. And here they're saying, you know, the district court issued an order stopping on a nationwide basis the president's invocation of the Alien Enemies Act. And now they're continuing to try to pry sensitive information from the government. And the co-equal branch of the executive branch should be respected. Now, most fundamentally, they write, the district court lacked jurisdiction. Judge Boasberg could not issue this highly irregular nationwide injunction, writing, this court has long held that the president's authority is not subject to judicial review under the Alien Enemies Act. The only exception is that individuals who are detained under the AEA may challenge the legality of custody in habeas, but here they intentionally waive their habeas claims, and there is no such thing as a habeas class action that would support universal nationwide relief like this judge made up out of his butt. Even if a court could review the proclamation that Trump issued, it expressly makes the two findings that the AEA require. In Trump's order, it follows the law. Under the Alien Enemy Act, Tren de Aragua is linked to the Venezuelan government, operates as a government unto itself there, has engaged in invasion and predatory incursion incursion into our country. Now, there is no basis for a court to look behind those facts under the law. That's the president's job. The president is accountable to the people for making those decisions because those are opinions. It's factual investigation, but you draw conclusions from the facts. We leave that up to the politically accountable branches. We don't leave that up to the judge to say, well, I disagree with the president on this policy decision. Otherwise, the judge is the president. And far from being novel, the president's invocation of the act in these circumstances is consistent with a long history of using war authorities against groups and entities connected to foreign states. But merits aside, Court of Appeals, the equities strongly favor the government, given the manifest harms to the public from letting dangerous aliens remain in the country. The injunction from the judge saying bring him back interferes with the president, violates his Article 2 powers, and is undermining the credibility of America with our international partners in Central America and jeopardizing international diplomacy. And so for all these reasons, the Court of Appeals should stop the improper interference by Judge Boasberg. They write, Trump to the Court of Appeals. As the government explained, the district court's unusual orders, while styled as TROs, are actually appealable because they say the nationwide halt can wait, but that's wrong. Even the order's temporary period has caused serious foreign policy harms that cannot be remedied. Boasberg has threatened to scuttle carefully removed operations that involve sensitive negotiations, and the court is continuing to pursue intrusive inquiries into Trump. This diplomacy is already fraught given the TDA's dangerous nature, designation as foreign terrorist, and being linked to hostile regimes. And challenges caused the prior administration to abandon the attempt to remove these people, but we're not going to do it. Now, you trying to undermine these efforts cannot be repaired even if the government wins, and the national security implications warrant immediate review. The court's orders are global. It makes removal of TDA members impossible. Even when a person does not pose a threat, removal delayed tends to become removal denied. And this is true a fortiori when dealing with some of the most dangerous criminals on earth. Plaintiffs agree immediate appeal is available from an order removing an alien to a country where he alleged he will face harm, but insist the government cannot immediately appeal an order to make it impossible to transfer them out. This can't be right. So for the same reasons, even if the court deems the orders enjoining this to be unappealable, it should nevertheless grant mandamus. If you don't grant us an appeal, there is no other way to protect the president's authorities or to safeguard Americans from the dangerous threats posed by the TDA. Further, the government's right here is demonstrated below, and they have no claim. So in the appeal, they write, a challenge to the AEA lies in habeas. If you think you've been wrongfully detained, file a petition for habeas corpus, and there is no other judicial revenue avenue. The challenge right now is to presidential action, which cannot be reviewed under the APA, the Procedures Act. And habeas provides the only historic basis for alien enemies to challenge their custody. Long line of cases that support that. And the district court lacks the ability to review this. For over a century, courts have held that a president's invocation of his authority under the Alien Enemies Act is, quote, not to be subjected to scrutiny by courts, even though implemented by others. Someone else in another case said, the statute vests unreviewable power in the president. This is binding. And if you're unclear about what it means, unreviewable means unreviewable. It leaves no room for the APA or non-statutory judicial review, much less sweeping national injunctions. The only limited review courts have is habeas, to challenge the detention of another person. And even plaintiffs in this case appear to understand that venue is improper in DC. They dismiss their detention claims orally in order to avoid the immediate custodian rule and are challenging elsewhere. And because jurisdiction is limited to habeas claims, there is no basis to certify a class to resolve those claims and apply this to all of the gangbangers in America. The district court also erred in failing to make affirmative findings under the rules. But they say their claims fall outside of habeas. But the problem is this: case law recognizes the only allowable challenge is a habeas claim, and so other theories of review must be rejected. They cannot sue for this. So in short, outside of this type of review, the control of alien enemies has been held to be a political matter subject to the president. They have no remedy other than a habeas petition brought in the district of their confinement. So the proclamation from Trump is lawful. The president can issue a proclamation. There is a declared war or an invasion or a predatory incursion. It must be perpetrated, and that hostile action must be by a foreign nation. And guess what? Trump said that exactly. It's the Maduro regime, functions as a government, parts of Venezuela, they're invading. And so they're trying to undo that. They say, well, it's not actually an invasion. They say it has to be a military invasion. But that's not what the law says. The full definitions of preferred dictionaries actually support us. Invasion means a hostile entrance into the possession of another. We're clearly being invaded. Now they say it's limited to foreign sovereigns. They say no. Actually, the TDA is a part of the Maduro regime. It is. It's virtually indistinguishable. There's no no compelling reason to say this doesn't apply to them. And their attempts to minimize the history of military action also misses the point. The U.S. is facing hostile forces at the border, and they can't illegally bypass other provisions. The AEA is a key authority that Congress has seen fit to retain, and it directs the president, including Roosevelt and Truman used it, to protect the country. And it's not subordinated to other areas of the law, and there is no conflict that matters or that is important here. So they say that the Trump doesn't have authority, but that doesn't withstand scrutiny. They fail to meaningfully address the long-standing Supreme Court precedent about the president's expansive authority over immigration, foreign affairs, and national security. The exercise of authority by the president, in this case, falls within the long-standing powers that we've already seen. Now, what this court has done is impede the president from using his authority to address a predatory invasion by a hostile group. The orders undermine the delicate international relations that exist between the countries, and individuals associated with TDA are being brought back into our country. The district court's orders divest Trump of its key powers of foreign affairs and national security. The equities plainly outweigh the equities of permitting illegal aliens linked to hostile powers and terrorists to remain in the United States. U.S. national security is of paramount importance, and they can file habeas claims, not class actions as gangbangers. So this court should stay the sweeping universal injunction, and precedent supports this. You are not allowed to probe the national security and foreign policy decisions of the president, and you limited procedures here. Your injunction undermines long-standing deference to the executive branch, and so for all of these reasons, Trump says to the Court of Appeals, Judge Boasberg's decision to stop the deportations of Tren de Aragua should be stayed, and all of his other orders should be stayed pending appeal. So that rounds out the TDA deportation case out of Judge Boasberg, and of course, we'll see what the Court of Appeals does. Thank you for subscribing and joining as we do.